All right. Well, good evening, everyone. I'm Brian Ponder, Brian, a credit lawyer. I'm a New York trial attorney, which means I'm admitted to practice law in the state of New York. I'm admitted also in several federal courts. You may see all these pieces of paper behind me. Those are different courts that I'm in all across the United States. And my practice focuses on consumer law. And what we're doing here tonight is a Zoom call. And the topic for tonight is my top 10 favorite sections of the FDCPA. And we're going to have a lot of fun tonight talking about the FDCPA. I know a lot of you are credit repair organization owners. I know some of you may be just individuals improving your own credit. What I want to do on each of these is start out by, I'm going to do some more presentations just about mindset, but I want you all to adopt the proper mindset when dealing with these credit issues. The reason is you're going to be going against some huge entities. When I say huge, they're going to have more money than all of us put together times 1,000, but it's not about that. It's about the law. The law is on your side. And so I want you to take the mindset that whatever your goal is, that you're going to accomplish it. So if you have negative items in your credit report, do not ever think that you won't be successful in taking them off. Don't even think about that. Your thought process is you're going to do whatever it takes, however long it takes, to make it happen. You can take that same mentality with your clients as well. But the reason we're going to go over these laws is because you can use these to your advantage. They're meant for you. They're not meant to protect the debt collectors or consumer reporting agencies. There's of the whole thing, there's about one line, there's one subchapter of the FDCPA and one subchapter of the FCRA that sort of protects them, but this is to protect consumers. So we're going to do more mindset talks, but I want y'all to understand it's very, very important because it's easy to get discouraged and it's easy to get stumbled with wrong information. So we're going to give you the right information. We're going to equip you to know where to find the right information so that if you see something wrong, you'll recognize it. Or if you encounter a problem, you'll know where to go to try to resolve it. You don't have to go buy something or rely on someone else. I'm going to show you how to find the law that's going to support you. Now, of course, you have to invest in resources. I have a whole row of books. We're going over FDCPA. I have a whole row of books. Let me see, I can pull one of them that just talks about the FDCPA. Let me see. I mean, these are just a couple. These, some of the stuff we're talking about is further explained in some of these books. But we're going to make it real simple for you. And we're going to get through it all. So we're going to talk about the top 10 items, sections of the FDCPA. Just a little housekeeping. I'm going to leave everyone unmuted. At any time you want to interject and ask a question, you may do so. What I ask is if you don't have a question or if you have background noise, just mute yourself. But anytime you have a question, just jump right on in. You're not going to throw me off because guess what? I have notes. So don't ever worry about throwing me off. I'll be able to pick right back up. All right, so I'm going to share my screen. We're going to jump right into it. There we go. So what I'm looking up here is, if you go to Google, basically the FDCPA, which stands for the Fair Debt Collection Practices Act. So if you go to Google, that statute is 15 USC 1692. You type that into Google, you're going to see law.cornell.edu, the Legal Information Institute. And that's a free resource where you can actually pull up this statute. When you click on the statute, it may take you to here, that first section, 1692. The sections actually start at 1692 all the way to 1692P. 1692A, and it goes all the way to P. We're going to talk about my top 10 favorite, okay? But this whole law is important. But I'm going to look at the top 10 that you're going to be using in your credit repair processes. Let's start here. Number one, all right? Number one, how are we doing on time? 9:07. Number one, my favorite section will be 1692A. Now these, number one doesn't mean my top favorite. These are all going to get equal weight, but we're going to start here, okay? This is definitions. Why are definitions important?
I wondered if I
Okay, we're going to mute. Okay, let me mute someone.
upgrade the internet if we have these.
Oh no, I'm about to mute.
Because I noticed with me working from home now I see a lot of connection problems.
All right, I had to mute someone. If you're listening, mute yourself if you don't have a question, and then unmute if you do. Definitions are very important. The credit repair process consists of writing letters and communications, okay? So the words you use are very, very important. You could use the wrong word, or you could use a word and not know what it is, or use the wrong word and not understand the difference. One word can make a difference. Let's look at some of these definitions. Bureau. When we think about, I think someone may be writing. I have to figure out how to do that. Let's see, how can I erase? Okay, there we go. It may allow you to do some annotation, but don't though. Bureau. When you see bureau, a lot of times you think CRA. No, bureau means the Bureau of Consumer Financial Protection, the CFPB. So that's what bureau actually means. So Consumer Reporting Agency actually is the correct term for like Equifax, but bureau legally in the FDCPA is talking about the Bureau of Consumer Financial Protection. Communication, what's that? You hear a lot about communications in the FDCPA. We're going to talk about it. Communication means the conveying of information. Okay? Conveying of information regarding a debt, directly or indirectly to any person through any medium. This is huge. This is huge. That means communication doesn't have to be a letter, doesn't have to be a phone call. It could be anything, any conveying of information, directly or indirectly. We're gonna come back to, you're gonna see the communication word again, and you're gonna appreciate that definition. Now, if you click on communication, they'll actually give you some more information, anything that's blue. So sometimes you can click on this and get a further definition of that word, or sometimes you can get the origin, because sometimes another law defined it, and that's why it's blue. The term consumer, so consumer means any natural person obligated or allegedly obligated to pay any debt. So what's a natural person? Well, a natural person is an individual, someone that has blood running through their veins, versus an artificial. You have two types of persons, artificial and natural. Natural, I'm a natural person, you're a natural person. An artificial person would be a company, okay? So when you see the word natural person, that's a consumer. So basically a consumer can't be a business. So if you have a client that has a business debt, and the debt's in the name of the business, well, that's not a consumer, that business is not a consumer. And so, and that person has to be allegedly or are obligated to pay any debt, any debt. So it doesn't matter what kind of debt. What about a tax debt? No, any debt. Creditor means any person who offers or extends credit, creating a debt, okay, or to whom a debt is owed. But that term does not include to the extent he receives an assignment or transfer of a debt in default, solely for the purpose of collection of that debt. We're going pretty fast tonight, but this definition is very, very important. Creditor. All right? Because a creditor is not subject to the FDCPA. Okay, so if Capital One, if you have a Capital One credit card and they keep calling you or doing this, that, and the other, you don't look at the FDCPA for that because they're a creditor. They extended the credit. What does debt mean? Debt is any obligation or alleged obligation of a consumer to pay money arising out of a transaction which the money, property, insurance, or services which are the subject of the transaction are primarily, doesn't have to be solely, but primarily for personal, family, or household purposes, whether or not such obligation has been reduced to judgment. Very, very important. Very important. Because you can have a consumer that has a business debt, like if you buy something, incur an obligation strict primarily for business. Well, guess what? That's not a debt under the FDCPA. So you got to understand. So when you have a client or when you are dealing with an issue that's a business debt primarily, well, that's not under the FDCPA. It needs to be primarily for personal, family, or household use, right? Purposes. Now, here's a big definition here. Debt collector. Let's read it. Debt collector means any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the collection of debts, or who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be due another. All right, that's a long definition. Let me break it down for you. Basically, a debt collector is someone other than the creditor trying to collect that debt. All right. Now, here's a little twist. Sometimes you can have a debt buy, not a debt buyer, but it could be a debt buyer, but most of the time it's not. But you could have an entity that buys a debt, but they not be a debt collector. That's a Santander type case. When you have that happen, the question is, was the alleged debt or debt in default before it was bought? If it was in default before it was bought, then that new buyer or owner of that debt is a debt collector. If it was not in default, they can be considered original creditor. They could be considered a person stepping into the shoes of the original creditor. But for the most part, you can determine that a debt collector is someone other than the original creditor trying to collect a debt. In most instances, what you will see is when you see a collection, it's definitely a debt collector who likely took over the debt when it was in default. They're either collecting on a percentage, or they're a debt buyer collecting, but those are debt collectors. You look down below, there are several exceptions of who's a debt collector, okay? You will want to review these. They're very important. So an officer or employee of a creditor, that's not a debt collector, a person while acting as a debt collector for another person. So all of these are exceptions, okay? So you're gonna wanna look at that. Hold on, my light went off. Let me fix my light. 1 second. Solo studio. All right, location information means a consumer's place of abode. That means home, and his telephone number at such place, or his place of employment. And we all know what a state is, right? Any state, territory, possession of the United States. So we spend a lot of time on definitions because it's very, very important, okay? All these words you're gonna see again right now. We're gonna go over it right now. So be sure to review this. That's one of my favorite sections. So let's check that out. That's number one. Number two, 1692B. We can just click next. Acquisition of location information. Oh, we just talked about that, didn't we? Remember what we said location information was? Abode. Let's go back. Remember that? Location information, place of abode, and telephone number there, or place of employment. Remember, see, these definitions come up. Very important. Now, this is why this is a favorite. This part of the law says any debt collector communicating with any person other than the consumer for the purpose of acquiring location information shall. Now, here's another word that you want to look out for. Anytime you see the word shall, that means this is a zero tolerance requirement. Shall means it must be done. So a debt collector contacting any person, communicating with any person other than the person that's a consumer, shall identify himself, state that he's confirming or correcting location information regarding a consumer. All right. And if he's requested, identify his employer. 2, not state that such consumer owes any debt. So if you come home and your sister said someone called saying they're looking for you because you owe a debt, that's a violation of the FDCPA right there. $1,000 violation, right? That's a violation. A debt collector cannot talk to someone other than you and say, hey, we're trying to figure out where John Doe is. You know, they owe a debt and we're trying to get them to pay it. They can't do that. Capital One, who's the original creditor, they can do that. But a debt collector cannot do that. What else can they not do? Not communicate with any such person more than once unless requested to do so by such person. They can't call your sister again trying to get location information. All right? Unless they believe the early response is erroneous or incomplete and that such person now has correct or complete information. So that's sort of like a little escape route if they want to call again. Not communicate by postcard. They cannot communicate with you or anyone else by postcard. Not use any language or symbol or any envelope or in the contents of any communication affected by the mails or telegram that indicates the debt collector is in the debt collection business, other the communication relates to communication with that. So on the outside of the envelope, it can't say, we're a debt collector trying to, you better open this. Can't do it. That's a violation. You should not be able to tell on the outside of the envelope. They also cannot, after the debt collector knows the consumer is represented by an attorney with regards to the subject debt, or can reasonably ascertain such attorney's name and address, not communicate with any person other than an attorney unless the attorney fails to respond in a reasonable amount of time. So if I write them a letter on your behalf or someone's behalf as an attorney, they can no longer communicate with that consumer or anyone else but me. That's why sometimes a person, can hire an attorney, and if that debt collector talks to that person again, that's a violation of the law right there. Another fine. That's number 2. So my third top favorite will be 1692C. Look at this. Communication in connection with debt collection. Remember what communication was? Remember that definition? Any conveyance of information, any purpose, by any means, right? Directly or indirectly. So these definitions, you have to learn those definitions because when you see this word communication, it's not like what you think. Phone call, letter. Nope. Any conveyance of information. All right. This is what I like about this one. This is what the law says. Without the prior consent of the consumer, given directly to the debt collector, or the express permission of a court, a debt collector may not communicate with a consumer in connection with the collection of a debt. And here are 3 things: at an unusual time or place, okay, known or which should be known to be inconvenient. All right. Well, what does that mean? In the absence of knowledge of circumstances to the contrary, debt collector shall assume. So they're going to give us some guidance. Shall assume. Remember, shall. That a convenient time for communicating with a consumer is after 8:00 a.m. and before 9 o'clock p.m. local time of that consumer. Okay, that's huge. So what does that mean? Can a debt collector call a consumer at 7:30 a.m. consumer time? No. If they do, that's a violation. That's a violation. So when I say violation, that means that's a violation of 1692, well, 15 USC 1692 CA1. That's a violation of that. That's a violation. 2, if the debt collector knows the consumer is represented by an attorney with respect to such debt and has knowledge or can readily ascertain such attorney's name and address, unless the attorney fails to respond, or unless the attorney consents to direct communication. So all that means that debt collector cannot contact that consumer if that consumer is represented by an attorney and the debt collector knows. All right. So that means if I represent you, but I never tell anyone, well, the debt collector doesn't know. But if I represent you and contact that debt collector and say, hey, I represent John Doe, they cannot contact John Doe, the consumer that I represent regarding that debt. Very important. If they do, it's a violation of what? 15 USC 1692 A2. Let's look at number 3. They cannot contact the consumer at the consumer's place of employment if the debt collector knows or has reason to know that the consumer's employer prohibits the consumer from receiving such communication. So before calling, you can imagine the debt collector won't know, but what if someone answers the phone and says, you know what, the employees cannot take these type of calls here. What if they call the next day? Violation of what? 15 USC 1692 A3, right? Very, very, very important. Part B of this, subpart B, communication with third parties, except as provided in 1692 of this title, B, without the prior consent of the consumer, given directly to the debt collector or the express permission of the court. A debt collector may not communicate in connection with the collection of a debt with any person other than consumer's attorney, a consumer reporting agency, otherwise permitted by law, or anybody else. This basically says, look, a debt collector cannot talk about that debt with anyone other than you or your attorney. The only way they can do that if they have the consumer's direct consent from the consumer. All right. All right. So that's what that means. So if your sister said they talked to her about your debt, that's a violation. A violation of what? 15 USC 1692 parentheses B. They can't talk about the debt anymore. Let's go to this one. Ceasing communication. If the consumer notifies the debt collector in writing. So look, when y'all reading this, you have to take your time, okay? Because you can't call them and say, don't communicate with me anymore. In writing. Brian, do I have a case? I told them not to call me, they called me anyway. Was it in writing? No. All right. If the consumer notifies the debt collector in writing that the consumer refuses to pay, all right, or that the consumer wishes the debt collector cease further communication with the consumer, the debt collector shall not. So we see that shall, it's a hard line, it's a bright line right there. Shall not communicate further with the consumer with respect to the debt, except, so there's an exception, to advise the consumer that the debt collector's further efforts are being terminated, to notify the consumer that the debt collector or creditor may invoke specified remedies which are ordinarily invoked by such debt collector or creditor, or applicable, to notify the consumer that the debt collector or creditor intends to invoke a specified remedy. So those are some exceptions. But look, if you write the debt collector, okay, look, in writing, if you write them and say, don't contact me anymore, they can't do it, except to tell you they're going to stop, or that they may invoke some remedies. If such notice from the consumer is by mail, notification shall be complete upon receipt. So You can't mail it, and while it's in the mail, they call you. That doesn't count. They need to receive that communication. So if you fax it, that's different. But you know, this works once they get it. All right, number 4, 1692D is on my list as the 4th item. Harassment or abuse. A debt collector may not engage in any conduct, the natural consequence of which is to harass, oppress, or abuse a person in connection with a debt. Well, harassment can be a lot of stuff, but look, they're going to give you some examples. 6 of them. To use or threaten violence, okay? Or physical harm, violation. To use obscene language, violation. Profane language, violation. They curse on the phone, that is a violation. What is it a violation of? 15 USC 1692 D, parentheses 2. All right. What else can they not do? The publication of a list of consumers who allegedly they can't publish. They can't publish you like that. The advertisement for sale of any debt to, of course, they can't do that. They can't put an advertisement to sell a debt in paper about you. They can't do that. Causing the telephone to ring or engage any person repeatedly. They can't call you back to back to back. Violation. Violation of what? 15 USC 1692 D5. 6. Acceptance provided in section 1692B. The placement of telephone calls without meaningful disclosure of the call's identity. They can't call and try to talk to you like they're your friend without identifying themselves. Violation. All right. Number 5, 1692E is on my list. We're moving right along. We're right halfway. We're gonna keep moving. I hit the wrong thing. Yeah, I hit the wrong thing. I think it's that's what you call that's a technical error. You're gonna hit next. It's supposed to come here. 1692E, false or misleading representation. A debt collector may not use any false, deceptive, or misleading representation or means in communication with the collection of any debt. All right, they can't do it. Guess what? The law gives you some examples. You're like, well, what can that be? That can be anything. But they're going to give you a few examples. Are we limited to these examples? No. But they want to give you some examples, okay? The following conduct would be a violation. False representation of the implication that the debt collector is vouched for, bonded by, affiliate with the United States or state. So what does that mean? They send you something, looks like a court seal on it. It says state of so-and-so, state of New York. No, that's a violation. What is that a violation of? 15 USC 1692E, parentheses 1. Number 2, the false representation of the character, amount, legal status of any debt, or any services rendered or compensation which may be lawfully received. So I like to use this one, okay? Because let me give you an example. Say the debt collector, say if you had a capital debt for $100, the debt collector buys that debt or collects that debt on contingency or whatever and tries to collect $110. Well, they're misrepresenting the character of it, the amount of it. I'm sorry, the amount of it, right? So what if it's $1 off? Violation of what? 15 USC 1692 2A. All right. I'm quoting this so you can understand when you see a violation, that's what it is. You should not be quoting these in your letter, but I'm just letting you understand what these violations are. The next one, the false representation or implication that any individual is an attorney or that any communication is from the attorney. So look, you see a lot of these debt collectors, they call themselves, you know, Doe and Associates. Well, that's fine. But if they say Doe Legal Group and there's no lawyer there, that's not fine. It's a false representation that it may be a lawyer. That's not going to work. Or if they say on the phone that they're lawyers and they're not, that's a violation. Violation of what? 15 USC 1692E, parentheses 3. 4, the representation or implication that non-payment of a debt will result in arrest. You see that a lot, right? On the news, mostly. If you don't pay this debt, we're going to send a police over. Violation. The threat to take any action that it can't legally take. This happens a lot. But we're gonna sue you. I think Warren, you're in Pittsburgh. We're gonna sue you in Philadelphia. Well, they can't do that, and you'll see why later. Well, that's a violation. The false, are we going to sue you where they're located and you didn't do business there? That's a violation. The false representation or implication that a sale, referral, or other transfer of any interest in the debt shall cause the consumer to lose any claim of defense of the payment or become subject to practice. So they can't say, oh, well, we're going to sell the debt and you're not going to be able to do this, that, and the other. That's a violation. The false representation or implication that the consumer committed any crime or conduct in order to disgrace it. So they can't try to say or implicate that if you don't pay them, you're committing a crime. Okay, that's not going to work. That's false or misleading. It's not a crime to not pay a debt collector. Communicate or threaten to communicate to any person credit information which is known to be or should be known to be false, right? Or including failure to communicate the debt is disputed. This is huge. So if you dispute the debt, that credit report later they have to indicate that it's disputed. That's where that comes in, okay? So that's a violation. They don't do that. If they communicate that you owe $110 to Equifax and you really owe 100, well, guess what? They violated this part 8 here, subsection 8.
I mean, enjoying what? I ain't enjoying nobody team. I got my own team.
The use, I'm a mute Cedric. The, where do we go here? Which one did I do? See, I got
Number 8.
All right, so we did 8. So number 9, the use of distribution of any written communication which simulates or is falsely represented to be a document authorized, issued, or approved by court. Okay. So look, again, this is sort of we just sort of had this one before, but if it looks like a court document, if it, they distribute something that looks just like something that's authorized by the state, violation. The use of any false representation or deceptive means to collect or attempt to collect any debt or to obtain information of a consumer. So basically they're being sneaky. That's when they do sneaky stuff to get information. They say, how you doing, man? Hey, man, I saw you today at the store. How you been? It's been a while. Sneaky information, sneaky things. That's where that comes in. So that's a broad one there. The failure to disclose the initial communication with the consumer, the person is attempting to collect the debt, and in future communication that they're a debt collector. Okay, I'm speeding through this so you can come back and read it because we have to move forward. But basically that means every time this debt collector communicates, they have to say that they're a debt collector. The first time, they have to say it's an attempt to collect the debt and information for use for their purpose. After that first time, they have to just basically say we're a debt collector. A lot of people get that confused. People think that they have to say the full thing each time, but the first time they have to say is they're a debt collector, attempt to collect the debt. And after that, just that they're a debt collector. Next, the false representation or implication that accounts have been turned over to innocent purchasers for value. Okay, that's a violation. The false representation or implication that documents are legal process. So if they say it's a lawsuit and it's really not, what if they send you a draft of a lawsuit and say, hey, look, we're suing you, but it's not filed? That's a violation. The use of any business, company, organization name other than the true name. So if they use a name that's not theirs, like I said, you see that a lot. That's a violation. The false representation or implication of documents are not legal process or do not require action by the consumer. So if they actually sue you and serve you and try to convince you otherwise, that's a violation. They try to convince you, oh, it's not really a lawsuit, that's a violation. The false representation implication that a debt collector operates or is employed by a consumer reporting agency, violation. They can't say, oh, we're working with Equifax on this, so if you don't pay us, we're going to do this. It'll never come off your credit or something like that. You can't do that. You can't do that. All right, any questions? We're going to actually, that's 5. Let's go to my next one. My next one, we're going to have to go back because it's not working right. Unfair practices. I'm going to jump to the one I use most often, but this whole one is one of my top. Unfair practices. A debt collector may not use unfair or unconscionable means to collect or attempt to collect the debt without limiting general application, meaning this first sentence is what the law is. Everything else are some examples. I like 1692 F1, the collection of any amount include any interest, fee, charge, or other expense incidental to the principal obligation, unless such amount is, this is very important, y'all. This is like one of my, actually, I use this all the time. Unless such amount is expressly authorized by agreement creating a debt or permitted by law. Okay, this is huge. I use this all the time. What does this mean? They can collect any amount that the consumer, I'm just going to say you, that you didn't agree to pay by agreement. You know what an agreement is, or by law. Very strong. I'm gonna let y'all read the others, but this is the one I use every day almost, all the time. Very important. Why? Because I'm like, well, show me the agreement. Show me the agreement that expressly authorized me to pay this debt. Or show me the law that says I have to pay it. Very strong. This is one of my favorite, of all of them, this may be one of my favorite ones, because you need to be able to show me the agreement or the law that says I have to pay this debt. Very strong. That's number 6. Number 7, 1692G. Let's see if I can get to G. Yeah, here we go, validation. This one is huge. Let's talk about it. It has 2 parts, 1692GA, which says within 5 days of the initial communication, the debt collector must give a written notice that says the amount of the debt, the name of the creditor, the statement that unless within 30 days it's disputed, they'll assume it's valid, a statement that if the consumer notifies the debt collector in writing within that 30-day period that it's disputed, they'll get verification or a copy of a judgment, mail it to the consumer, and a statement that the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor, okay? So very important, y'all, because the initial communication, when that happens, within 5 days, it's usually with the initial communication, but within 5 days of that initial communication, if the debt collector does not send a notice that has these 5 things in it, guess what? They have violated 1692GA. Very important. 1692GB, very important. How to dispute. If the consumer notifies the debt collector in writing, okay, again, so you can't just call them up. You cannot just call them up. In writing, you're gonna have to use some stamps here, or you got the fax, you have the email, in writing. Within the 30-day period, we talked about above, that the debt or any portion thereof is disputed, or the consumer requests a name and address of the original creditor, the debt collector shall, okay, cease collection of the debt. What does that mean? Stop. So again, all this stuff, this is where you're going to become your own lawyer, okay? You're your own lawyer here. You got to read all those words. In writing, consumer has to notify the debt collector in writing within a 30-day period. So all this stuff has to happen, has to be from consumer to the debt collector in writing within 30 days that is disputed or any part, or that the consumer requests the name of the original creditor. The debt collector shall stop collection of the debt or any disputed part until, so that means they have to stop until the debt collector obtains the verification of the debt or a copy of the judgment or the name and address of the original creditor. And so that means, and means it has to happen too. And a copy of that is mailed to the consumer. All right. So they have to stop collecting until they mail it to the consumer. All right. If they don't, what if they keep collecting on it, before they send you that verification stuff? That's a violation. Collection activities and communications that do not otherwise violate the subchapter may continue during the 30-day period referred to in subsection A unless the consumer is notified the debt collector in writing or any that the debt or any portion of dispute or the consumer requests the address of the original credit. So basically, that's saying, and I had a question by someone, another person that's a credit repair person. Basically, during that 30-day period, that initial 30-day period, they can communicate all they want, unless the consumer does, this dispute process in writing, okay? They can do that. So, because someone asked me the other day, well, guess what? This debt collector put this on my credit, but they didn't write me yet. Well, keep in mind, they can do that. But as soon as that person in writing disputes it, they technically needs to stop that collection process. And by the way, credit reporting is collection. So a lot of times, if they throw it on the credit first, before letting that 30 days pass, and if you dispute it in writing timely, technically it needs to come off the credit report. If it doesn't, that's a violation, right? Unless they pretty much, as soon as they get it, courier over the documents, the verification documents to the consumer, they technically have to stop credit reporting. Any collection activities and activities during the 30-day period may not overshadow or be inconsistent with the disclosure. So the overshadowing is a little deeper to understand what that means. They can't overshadow these rights here. All right. So that's my favorite part there. But you can see here, a communication in the form of a formal pleading shall not be treated as initial communication. So that means if they right off the bat sue a person, that technically is not an initial communication. Therefore, it won't trigger Part A, right? All right. So that's number 7. Number 8. My number 8 on the list is 1692G. I'm sorry, 1692I is my number 8. So we're going to go to I. Legal actions. Any debt collector who brings an action against on a debt against a consumer shall, in the case if it's a real property, it needs to be where the property is located. You're not going to see a lot of that, but in a case of where it's not a real property, it needs to be in a judicial district, basically in a county where the consumer signed a contract or where the consumer lives. Got it? So Warren, they can't sue you on a debt in Philadelphia because you live in Pittsburgh. Unless you sign that agreement in Philly, they can't do that. So if they insist on suing you in Philly because that's where they are and it's convenient to them, and you didn't sign anything in Philly, that's a violation. A violation of what? 15 U.S.C. 1692 I A 2. All right, so that's how that works. Number 9. My number 9 will be 1692 J. What does 1692 J say? This is again a little repeat, because remember back we talked about deceptive forms. You know, so this law, this FDCPA gives you plenty of opportunity. It gives you a few angles to hit them. It's unlawful to design, compile, and furnish any form, knowing that such form will be used to create the false belief in the consumer that a person other than the creditor of such is participating in the collection of or any attempt to collect a debt, when in fact such person is not so participating. So to make it look like someone else is collecting when they're not, you know, like it seems like Verizon's collecting, but it's not. You're a debt collector. Okay, that's deceptive form. Any person who violates this section shall be liable to the extent as a debt collector in 1692K. We're going to get to K. But yeah, so a deceptive form like this is a violation. Okay, that's number 9. 1692K is my number 10. Then we're going to have some time for questions. We did pretty good, 45 minutes. That's what I anticipated. So 1692K, number 10 on my list. And again, these are not in any particular order, but number 10, guess what? This talks about if they violate the FDCPA, a debt collector, of course, because remember, they would be a debt collector. Civil liability, that means this is what happens when they violate the FDCPA, except as otherwise provided in this section. Any debt collector who fails to comply with any provision, any one of them, it's a lot of this subchapter with respect to any person is liable to such person in an amount equal to the sum of, and guess what? We're going to have a list of things. Add it up, sum. Any actual damage sustained by such person as a result of such failure. Ooh, what does that mean? Any actual damages. What if they call you, start cursing, You have a panic attack, heart attack, can't breathe, take you to the hospital. Hospital bill, $10,000. I mean, those are actual damages. You're stressed out, you go see a counselor, you're depressed, you lose your girlfriend, lose your wife over the stress or something. I mean, that could be significant. Number two, in the case of any action by individuals, such additional damages, okay, that the court may allow, but not exceeding $1,000. So if you're a natural, as an individual, you can also get additional damages up to $1,000. These are called statutory damages. Number one is actual damages. Number 2A, statutory. All right. Think about this. What if you can't prove actual damages? That's fine. You can get that $1,000 up to $1,000 statutory. Okay, that's why that's there. If it's a class action, you can get such amount the court may allow without regard to the minimum individual recovery, not to exceed $500,000 or 1% of the net worth of the company. Okay, so if you take it doing a class action, this applies. Number three, in the case of successful action, you can basically get costs and reasonable attorney's fees. Remember I told you about there's a little part that protects the debt collector? Well, here it is here. On a finding by the court that an action under this section was brought in bad faith or for the purpose of harassment, the court may award the defendant's attorney's fees reasonable in relation to work expended. So if you bring a claim in bad faith, you can't do that. They'll make you pay the debt collector's attorney's fees. So a bad case doesn't mean you lose. That means there's no violation, but you brought the case anyway. Doesn't mean just because you lose, you're going to pay their fee. That's not the point. It has to be in bad faith. So bad faith means you don't have a case. You're just doing it to harass them. So that's how that works. It's not about losing. So don't be afraid to bring a case that's valid. And if you lose, you don't have to pay their fees just if you bring it in bad faith. This is some things they consider in the amount of liability, the frequency, persistence. If it's a class action, the persistence of the noncompliance. All right. Now, this is sort of like another little out for the debt collector. A debt collector may not be held liable in any action if the debt collector shows by preponderance of the evidence that the violation was not intentional and from a bona fide error, notwithstanding the maintenance of reasonable procedure. So they're always going to say that, oh, it was a not intentional bona fide error. That's their defense always. What can you sue them? You can sue them in any court of competent jurisdiction. Okay, you just have to be sure that debt collector is subject to jurisdiction in that court. Now, if you live somewhere and they're hurting you, wherever you are is fine jurisdiction-wise. If you're suing them in some exotic place that neither you or the debt collector has, any relation to, then that's the wrong place. Look, y'all, we're open for questions now. We have 10 minutes. That's my number. That's my top 10 FDA sections. What do y'all think? You're gonna mute yourself.
Hey, Brian.
Yep.
I got a question for you. As far as getting them sending you validation, what do you consider as proper validation from a debt buyer?
Okay, well, that's a good question. And that's one. So validation, that's 1692G, right? And it's GB. Technically, it doesn't really say. So you remember where I said, let's go back a little bit. You remember what I said in F? You remember what I said in F? That, look, F1, the agreement, I would ask for that agreement that expressly authorized that debt. But if you look at GB, it says you can dispute it. or ask for the name and address of the original creditor. So you can dispute it and say whatever you want and request whatever you want, technically. But ultimately, I would want to see an agreement that expressly authorized that debt. I would also ask for the name and address of the original creditor too, because that's one that's identified here. We know they have to give you that. So always ask for the name and address of the original creditor, because that's statutorily proven. Now, if you ask for the agreement, sometimes they may try to say, "Oh, we don't have to give you that. We don't have that," because the law doesn't express what exactly they have to give you. They just say it just says until the debt collector obtains verification. So obtains verification of the debt. That could be anything, but if you ask for something specific, you can make the argument that that's the verification you're looking for.
That sounds good. You're saying that like if they communicate with you, like they keep calling you and bugging you.
Mm-hmm.
As far as violation, can you sue them on that?
Yeah.
And sue them for the TCPA, the telephone communication one too, and like double dip on it.
Yeah, you could. Yeah, you can bring in other claims. You can bring in defamation. You can bring in TCPA. Absolutely. I'm sure it can. Let me see. We have a chat question. We have a question here. Any other question, more?
No, I'm good.
All right. Tania asks, can the harassment for TCPA be used for creditor as well? Yeah, the TCPA applies beyond debt collectors. But most of the time, well, the answer is yes. Okay, I'll just say it like that. But a lot of times people give original creditors permission to contact them, by phone, cell phone and stuff. So, but the answer to your question is yes. All right, so look, those of you that have my book, 4 Steps to Better Credit, it already gives you a leg up because it basically has the proper language in it to do a proper dispute under 1692 GB. All right. So, if, in that book, 4 Steps to Better Credit, it actually it has a template for you, and you pretty much just fill it in the blank. Now, here's a question no one asked. Well, can I dispute it after the 30-day period? Yes, you can. If you dispute it after the 30-day period, well, guess what? It does not technically trigger the 1692 GB requirements of verification, but you can still ask for it. The debt collector does not have to give it, though. Very huge to understand that. All right. We have a question from Mance. Does dispute has to be in writing under GB? Under GB, yes, it does. In general, no, it doesn't. Okay, what do I mean by that? If you're doing a GB verification dispute within the first 30 days to trigger 1692 GB, that has to be in writing. Remember, it has to be from the consumer to the debt collector. Well, it can be, from the lawyer or whatever, but from the consumer to the debt collector in writing within 30 days for a GB dispute. Okay, so if you call it in, that's not going to activate GB. It's going to activate, you remember we talked about reporting it as disputed. It will activate that dispute obligation to say that it's disputed. But if it's not in writing, it won't activate GB, but it will activate the debt collector to advise any publishing of that debt with a CRA that is disputed. Does that make sense, everyone?
All right. I have a question.
All right.
All right. Yes. All right. When a debt collector go ahead and buys the debt from someone, all right, that debt is no longer yours. Can you write it off as what is identity theft?
The way you wording that, nah. Because when you say writing it off, I don't know how you.
No, I'm talking. What's the word? Disputed as identity theft.
They bought it. Disputed identity theft.
Cause really I want to know, all right, cause if I have a account with Belts, you know what I'm saying? I have agreement with Belts. I don't have an agreement with the third party or any other place, correct?
If you don't, you don't. I don't know. I hope you don't.
Yeah.
I mean, if they, I'd assume you don't.
Yeah. So when they can't use that, you know what I'm saying, to showcase your debt, cause like I said, you don't have that debt with nobody else but Belts.
Okay. Well, back to your original question. Yeah, it's not identity theft.
Okay.
That's just a dispute. I mean, you're just saying I don't have, if you download my 1692 GB letter, which is in my book, see what it sort of encompasses what you're trying to say is, look, I don't owe you any money.
Yeah.
Okay. And that's where you need to go. I would not use the word identity. Identity theft is different.
Okay.
Than what you're describing, but you don't have to go there.
All right.
Hey, Brian, I got a question.
Go ahead.
I may have missed this because I got on late. Your letter, I have a copy of it. After the Dunning period, and it's a collection.
Mm-hmm.
Can we still use that letter on the first round of disputes?
Yes, indeed. Yes, indeed. So I just mentioned that. So my point was, if you send that dispute letter, that 1692 GB letter that I provide you with, after that 30-day period, guess what?
Mm-hmm.
The debt collector does not have to send you a verification. But that letter does not trigger that. Okay? Because it's outside the 30-day period. Now, most debt collectors, out of an abundance of caution, will go ahead and verify it. Some will write you back and say, look, we don't have to verify this. We're outside this 30-day period. Our initial communication was to you a year ago. Okay?
Okay.
But you can still send it. Why? Because it still invokes you disputing that debt. We have a question here. Does that answer your question, Cedric?
Yes, it did. Thank you.
You're very welcome. So here's a question. If one has submitted a dispute letter to creditors for a debt, what can a cosigner do to protect themselves? Well, first of all, creditors are not debt collectors. So it will not invoke anything we went over tonight. If it's with a creditor, that is just looking at the original agreement with the creditor. A cosigner can protect themselves by just getting information, getting a copy of the agreement, getting a copy of the payment history, reviewing the agreement, reviewing the payment history, and making sure and seeing what their obligation is under the agreement, whether the cosigner agreement or the original agreement with the primary account holder. That's what I would do as a cosigner to protect themselves, to review the actual agreement and payment history, to understand what the cosigner's obligation is under the arrangement. All right, so any other questions, anyone?
And Mr. Ponder.
Yes.
It's Vance.
Mm-hmm.
Well, you know how I asked the question about disputing in writing?
Mm-hmm.
Actually, in the notice, let's say the Dunning letter, sent to the consumer that's required by this section,
Mhm.
it that Dunning letter shouldn't have any language about the consumer disputing in writing. And so probably 8 years ago or so, I won a case on GB because it says if the consumer notifies the debt collector in writing. Well, if it's optional. And so usually I'll pick up the phone and I'll, start verbally disputing. And I'm looking for the debt collector to say, hey, put that in writing or something along them lines. And by them saying you have to dispute in writing, that's the violation because I use section GB where it says it doesn't have to, it's optional.
Yeah, you referring, Vance, to GA. That notice says
GA3.
if. Well, the statement in part 3 and 4, it says if. So no, they can't say you have to dispute in writing. No, that is a violation because that's an option. They can't tell the consumer they have to dispute in writing. It has to say if. And you're right. If they're calling you and saying, well, you disputed, no, they can't say you have to write them because you're right. They do that. That's a violation. But if you want to trigger 1692 GB, it has to be in writing. But they can't.
Yes.
You can't say you have to dispute in writing. No, you can't call. No, that's a violation. That is correct.
Yes, and I can't remember exactly what the guy's question was, but you can, within this section of GB, it says any portion thereof. So if there's a dispute on the authorization of their authority, say, look, because he was saying something about a contract, I don't know you or something like that.
Mm-hmm.
You can just, hey, listen, my dispute is, the authorization of your authority. Show me that before we can even get to the contract.
Right.
And so,
right. You can ask for the contract. You can ask for their authority to act on behalf of the original creditor. You can ask for all that. Absolutely. Absolutely. You can dispute. You can dispute that. Good point, Vance. You can ask for all that. I mean, it sort of leaves it open. Your dispute, could be part of the debt. It may be what it means by part of it. Yeah, you think you owe, like I said, I owe 100, but I don't owe that 10 that you asked for. I don't owe that $10. So that's a part of the alleged debt. So absolutely, all that's wide open to be disputed. Well,
I got a question. So when you're requesting the 5 different pieces of information, saying,
where you get that 5 from?
I'm not sure the number. I'm sorry, because I can't find it on the website here. You outlined it.
The 1692 G80s5 right here.
Yeah.
Okay, you don't request this now. They have to send you this within 5 days of initial communication. You don't request this. They have to send this. If they don't send it, the violation has been made, has been had already. You don't request that.
and sorry to interrupt, but
hold on. We got a question. What's the question? I was just correcting you. You don't request that, but what do you still have a question, Lyle?
Okay, so how do you so if you're putting together and you're wanting to, so how do you bring this about? Like, which tool do you use to execute? You like really saying, I need this. I mean, my understanding of it is that you're saying, hey, you have to have all these pieces of it for the debt to be valid. Like, let's say you got a collection company. The debt's been sold to them, and they don't have all that information. How do you go about requesting, proving, validating? I'm not sure the right word, but
Okay. Well, Lyle, right?
yes.
All right, Lyle. Do you have a copy of the book 4 Steps to Better Credit?
I've ordered it. I'm waiting for it from Amazon.
Okay. Have you emailed me already on that?
Yeah, you sent me the letters that I have them in my email box.
So there's a letter called 1692 GB letter.
Uh-huh.
That's the letter you send to dispute it. Now, what you're asking, and I understand the question you're asking, is just that these 5 things here, you don't request. If they didn't give it to you, you've been violated already. No need to even request it. If they communicated with you and have not told you the amount of the debt, the name of the original creditor, these statement here, the statement here, and the statement here, the violation has already occurred. You pretty much already got them. You pretty much, at that point, they owe you $1,000 at that point. You don't, you already got them by the, you already got them now. Okay. But you can still, you can still dispute. But if they didn't give you these 5 things here that you sort of referring to, if they didn't give you this already, they've already violated you. So you shouldn't have to ask for that. But as far as 1692 GB, yeah, you can ask for verification, ask for that original agreement, ask for, like Vance was alluding to, their authority to collect on behalf of that original creditor. Or if they said he bought the debt, well, show me how you bought it so I can be sure I'm paying the right person. Yeah, you can ask for that. But yeah, if they didn't give you these 5 things here, you've already been violated, and you need to exploit that. And what I mean by exploit it, I wouldn't give them any money. And if you use a 1692 GB correctly, if they don't do that correctly, then they don't need to give you any money either. If they can't really prove themselves or comply with this dispute, the majority of the time, that debt collector is going to cease and desist that collection of that debt and delete it from the credit report with the letter I have drafted for you to use, 1692 GB. You'll see the letter, but you won't be asking for these 5 things. If they don't give it to you, you're good. Any other question, anyone? We're going to wrap up.
Well, this is Vance again. I wanted to add that is for the credit repair people or whoever, look at these notices, these Dunning letters, look at them very close, because a lot of the times they use debt collectors routinely use a company that's out of California or Minnesota to generate these letters, and they have an error in the letter. So they didn't send this letter off 500,000 times. So that's where the class actions come in and things of that nature, but it's very common.
Hey, Brian, I got a quick question.
Uh-huh.
What do you recommend when a debt collector calls you and you answer the phone? What kind of things do you recommend you ask them or tell them, or do you not recommend talking to them?
I don't recommend talking to them. If you're going to say something, I would say, well, I really don't recommend talking to them. So let's say they get you. This is Warren, right? So am I speak to Warren? Hey, this is he.
Yeah.
Hey, Warren, this is ABC debt collection. Hey, no, ABC company. All right, how can I help you? Well, we need to verify some. We need to verify that I'm talking to Warren. Is your date of birth 1/1/1970? I don't verify information by phone. Do not verify yourself on phone. Okay. They're doing that to make sure they're not talking to someone else. Okay. And so do not verify yourself to them. Well, we need to verify we're talking to you. Well, look, what I would do, I would say, well, whatever you're trying to contact me about, send it in writing. Well, Mr. Warren, is your address 123 Main Street, Pittsburgh, Philadelphia? What do you think my answer to that is, Warren?
Well, you obviously have my address.
No.
Wherever you want.
No. Well, that's close. And I like that, Warren. But I would say I don't verify information by phone. And just like you said, If you know me, send it where it's, you know, wherever you want, but I don't verify by phone. So don't verify. So that's the conversation. Or you can just hang up. Or you can just hang up. Okay. But that's what I usually do. You know, or you can say, once you can determine, if you can figure out who it is, you know, you can, it's declared, you can say, don't contact me anymore. But remember, you have to get that in writing, so you got to figure out who it is. But yeah, so Warren, I really, you know, you're not going to get far with them because you're not going to verify yourself, and they're not going to probably want to talk to you in specifics without you verifying like date of birth, social security number, all that, and do not do that. Don't do it. Any other questions?
No, that's it. Thanks.
All right, you all. Yeah, great questions. Great job. And what I'm going to do is I'm going to eventually get a little credit master certificate program for you all, so you can go if you attend 5 of these lectures. I'm going to put together some quizzes, and if you get 70%, you're going to pass the quiz and get at least 5 of those. We're going to get you a nice little certificate, credit master, certified credit master. So yeah, good job. So you know, I'll put this up on a replay, so you'll be able to reference it, and then I'll get a quiz out to everybody that you'll be able to take at your leisure. And all right, so yeah, thanks everyone. Look, if you're in the WhatsApp group, you'll be notified of the next Zoom. And if you're not, you might want to contact me and try to figure out how to get into that group. And we'll do this again very soon. Everyone have a good night. Be safe. Wash your hands. Don't breathe without protection in front of your mouth. And y'all have a good night. Hope to see you very, very soon again for another great lecture.
God bless.
God bless y'all too. And God bless America. All right, let's see. Stop sharing.